Who are you, Dilbar Ali?
I'm the assistant teacher, my lord. Here, my lord, see the sections, my lord. The 10 and 74, my lord. So here, my lord, less than 7.
Allegation is there of touching private parts of the body.
My lord, charge sheet submitted and charges also framed. I'll show that order, my lord. Lordship, kindly see the framing of charge order, my lord. That lordship find, my lord, page 33, my lord. Because charge sheet was submitted under other section, my lord, page 32, my lord. Lordship see para 2, my lord, page 32 first, my lord. That's 74, 75, 2, 79, 10 and 12, BNS and 10 and 12. But my lord, after going through the records and the statement, my lord, kindly have a look at page 33, my lord, 33. Charges, my lord. Under, my lord, that section 10, my lord, second line, accordingly charges, my lord. Section 10, also alternatively 75-2, and my lord, another section of the BNS 351-3, my lord. In fact, there was a offense under 75 of the Juvenile JJ Act, my lord. That also, I don't know, my lord, whether inadvertently or what, my lord. No, nothing against that, my lord. No statement made, my lord. And in fact, here what has happened, my lord, that on the date of occurrence, my lord, he was detained, my lord. Although I am not on that now, my lord. The occurrence, my lord, 17/6.
No, ultimately charges have been framed under what?
Those two, my lord. Kindly have a look at page 33, my lord. Section, my lord, 10 of POCSO, my lord. Alternatively, 75-2 and 351-3, my lord. Those two sections, my lord. And other section.
So POCSO is there.
POCSO is there. Yes, POCSO is there. I'm not on the. What has happened, my lord?
So why should we dispense with the notice?
My lord, that no notice under 41A35-3, my lord. Kindly see the forwarding report, my lord.
They didn't issue notice, so we'll also not issue notice.
My lord, here, my lord, what has happened? I'm not. Why, my lord? Because, my lord, here what? Day to day here.
It's not conditional.
My lord.
We can only consider these things after the notice.
Apparently, no statement has been made in the forwarding report, my lord. I leave it to lordship discussion. Only thing here, my lord, what has happened, my lord? Day to day trial has been given, my lord. And other than that, my lord, under it is good, my lord. Within 12 days, charge sheet was submitted. That also lordship find, my lord. And he's around 58 years, my lord. And we say that there is some animosity, my lord. I'm not on that now, my lord. Page 22, my lord. FIR was lodged on 18/6 and charge sheet submitted
36. None of your submissions will let me get over the division bench decision. Okay.
Yes, that is true.
If that is true, what is
But
false?
there is judgment of that Ernest Kumar and until also, my lord. Both are, my lord, in that interim power is possibly there, my lord, and we are not seeking absolute bail, my lord. I'll leave it to lordship, my lord.
Since it's coming from a court, we
Yes,
have the TCR. So.
13th of August.
My lord, here, my lord, with all respect, because day-to-day hearing, we have challenged that order also, but day-to-day hearing, my lord, that trial. So, my lord, we are prejudice, my lord, we are inside, my lord, and around 42 days. And
It has to be served, man.
So many day-to-day trials take place when people are inside.
My lord, if possible, short date and
Short date, give a shorter date.
and maybe amicus may also be appointed, my lord.
8
of August.
Everything will be over by then, my lord, because that schedule also we have annexed, my lord.
8th of August, man, next week, my lord.
I understand, but that schedule, I'm insisting on that schedule of, my lord, that day-to trial also we have given, my lord.
Where? What is the schedule?
Just lordship will kindly see page 36, my lord.
7th.
From 3/8, my lord.
25 or something.
Day to 3, 4, then 1, 2, 3, 4, 5, 6, 7, 10, my lord. Within 12 days, charge sheet was submitted. The parents also not examined by the agency, my lord.
If Malat by today steps will taken, it will possibly will go by Monday, and said by them. Registry also took time, Malat, for preparation of the notice.
Hard learned counsel for the petitioner and learned additional application under so and so. submitted that the present case day-to-day trial has been ordered by the learned trial court commencing from 03/08/2026, and hence it is necessary that the present application be disposed of at the earliest. Since provisions of the POCSO Act are involved, the informant is necessary. At the same time, the matter is required to be disposed of the earliest. Accordingly, the learned trial court is directed to send the scanned copy of the TCR by 4th of August without fail. As far as notice to the respondent number 2 is concerned, the petitioner may take steps in the course of the day, in which case the registry shall communicate the same through the concerned police station to the respondent number 1 by tomorrow itself, tomorrow's date. Further, considering the exigencies of the case, so and so is appointed as amicus curiae to represent the victim in the event the victim does not engage any counsel of her own after receipt of notice. Is the matter again on 4th of August.
Much obliged, highly obliged.
Who is there? T. Parasar, amicus. Okay. You serve copy today, both sides.
Fine.
Okay. Is there?
My pleasure, Your Lordship. Regular bail application, Your Lordship. Lord, this matter was tagged with AB number 1543, item number 54. But my lord, wrongly tagged with a BA number, my lord, 1543. This matter was listed on 27/7, Your Lordship.
So it is item 60 is otherwise should be tagged with today's item number 55.
54,
54.
53 and 54.
Okay, we'll take up when 54 is called.
Come to know CD is not received, Your Lordship.
It did not receive.
The day before yesterday, Your Lordship, was supposed to grant bail, my lord, and the connected matters.
Otherwise,
This
this is a
so-
POCSO case, Lord.
My lord, section involved in this case do not attract against the present petitioner, Your Lordship. Kindly peruse the FIR, Your Lordship. Case 8 is the FIR, Your Lordship. I am not the main accused, Your Lordship.
They taken with the, along with the 53 and 54, Lord.
All right, let that be called up. We'll see then. Call up 54.
Obligation.
May please, Your Lordship. So anticipatory bail application, my lord, FIR is at page number 16, my lord. May I refer the vernacular one, my lord, that is on page number 22. May I read, my lord?
So what to do?
My lord, here, my lord, I have some submission, my lord. This is the second FIR, my lord. There is a love relations. Earlier also an FIR has been lost. And that FIR has already been charged sheeted and trial is going on. And next date is on 1st of August, my lord. So for the allegation is this FIR, there is a love relations admittedly, my lord. On the day of occurrence, the victim herself called the petitioner before the BN college. I have annexed the Instagram, my lord, messages, my lord. And she pressurized.
No, no, what other case you were talking about? That
No,
is
not
also against
this-
you.
this-
Huh?
About this case, I have to.
No, no, just now you mentioned some other charge sheet has been filed where?
There is another case, same victim, mother of the present victim lost the FIR against the same petitioner, my lord. But that is under trial. But regarding this FIR, my lord, the victim herself called the petitioner before the BN college, and my lord, she pressurized her to take her because the parents of the victims want to give her marriage to other persons. So she took her to her uncle's house, and later on the he called his father. And after discussion, his father called the father of the victim, my lord, to come to take her daughter, but he did not come. Therefore, the family of the petitioners, my lord, handed over the girl to the police station, and police handed over the girl to the parents, my lord. But on the same day, then did not lost any FIR. On the next day, lost the FIR, my lord. This is reflected in the FIR itself that the police has handed over the girl to the father of the. And another case is pending, the same victim, my lord, same, and that is on 1st of August. My lord, at this, I only pray for an interim protection so that I can appear in the trial because this is on evidence stage, my lord. If I could not appear, my lord, maybe, my lord, warrant may be issued, my lord, against me. Yes, sir. Because police handed over the girl to the parents, my lord, and parents never lost any FIR on that day, my lord. On the very next day, it was lost, my lord. ফাৰ্ষ্ট পেৰাগ্ৰাফ ইট ইজ ৰিটেন মানে পিছত উক্ত দিনে ৰাতি পুলিচে মোৰ উক্ত ছোৱালীজনীক চমজাই দিয়ে
How did police get hold of the girl without any FIR? Where from did they find her?
Family handed over the girl. I have annexed the Instagram messages, my lord. She have an Instagram account under the name of Riha, my lord. And there is a love relation between the alleged victim and the present petitioner. Because of the pressure of the girl on that day, my lord, the petitioner took her to his uncle's house and called his father, petitioner's father. And after petitioner father come to the house of his uncle's, my lord, there was discussion, and the father of the petitioner called the father of the victim and asked him to come to the uncle house of the petitioner uncle house, but he did not come. Therefore, the parents and the family member of the petitioner handed over the girl to the police station to hand her to her parents, my lord. And accordingly, the police handed over the girl to the parents. No FIR was lodged on the same day, my lord. On the next day, the parents lodged the FIR against the present petitioner.
This after you were granted bail in the earlier case.
Earlier, it is in.
You haven't learnt your lesson now.
I have annexed my lord Instagram messages, my lord.
Whatever, you were arrested, you were facing trial in that case. You were released on bail. Thereafter, you again go and
The present petitioner also
start messaging.
teenage but 20 years old, my lord.
Huh?
The petitioner is 20 years old, and the victim girl is near about 18 years.
Red Heart Learned Counsel for the petition. This is an application on so. Two. Call for the CD. I call for the scanned copy of this. This is also charge sheeted, no? Call for the CD. Respondent number 2.
Notice also need to be issued. Lord.
Huh?
Notice also need to be issued.
Yes, notice to the respondent number. Having regard to the documents annexed to the instant bail application, including the exchanges between the petitioner and the victim over Instagram. Victim is at about 17 years, okay? Directed that event of his arrest, the petitioner shall be done. Carrying bail of rupees 50,000 with 2 securities of like amount. Action of the arresting authority. The directed that the petitioner shall appear before the IO within a period 10 days from today.
File your present.
Please again on.
My objection may be recorded on the ground that there are, in the FIR, there are specific allegations are there.
And additional the prayer for action. Yes. In view of the material available in the FIR.
File your present. File your present.
In view of the material allegations made in the FIR.
This 42 applications at this stage, case diary may be called for also.
Please, Your Lordship. An anticipatory bail application, Lordship, here, what has happened? The Lordship may kindly see that I am not a named accused in the FIR. Lordship will find that FIR in page number 23, Lordship. This is regarding some amount of misappropriation done at the level of Assam Fisheries Development Corporation Limited, and some officers were arrested. Now, what happened, Lordship? A notice under 91 CRPC was issued to me. Lordship will kindly find that notice under Annexure 3, page number 24, asking me to produce certain documents. Very fairly speaking, Lordship, what has happened? Here, the works were executed through the help of some other third party, and few documents I was not having. But since I have undergone one operation, Lordship, I have written one letter. Lordship will kindly find that letter is in annexure number 5, page
Sorry,
26.
not before me.
Lordship.
Place the matter before another bench without me. Yes, K. Sharma. Thank you.
Can a date be, Lordship?
All right. Friday.
31, on 31.
Friday.
Friday. Diplomacy.
Yeah, please, Your Lordship. Hearing Your Lordship, the petitioner number 2 has lodged an FIR against the present informant respondent number 2, Your Lordship. Your Lordship may kindly see page 16, Your Lordship. Page 16.
This is for what? Quashing?
Yes, Your Lordship.
Quashing of charge. Is it charge sheeted or FIR?
Charge sheeted. It is charge sheeted.
The stage of appearance, let us statement.
It is charge sheeted, Your Lordship. And the present FIR has been filed as a counterblast to our FIR, Your Lordship. And there was a medical report. It was registered under section 341, 294, 307, 511. Then the police report, there is no body injury, Your Lordship. So section 307 doesn't come, Your Lordship. Then, Your Lordship, other sections are available sections, Your Lordship.
Not a bail application, but does it matter if it is bailable or not bailable?
Yes, sorry, Your Lordship. I lodged an FIR which was registered as Sukhchar PS case number 7218 under 120B 341 354, read with section 6 of POSCO against the present and the present informant, respondent number 2, and his son were arrested. Now, as a counterblast, thereafter they lodged an FIR which was registered as Sukhchar PS case number 73 of 2018, Your Lordship. We have filed an affidavit and to which we have filed our counter, Your Lordship. The allegations. The basic allegation was that the petitioners attacked the respondent informant while he was going to school, and they tried to snatch some documents and assaulted him. But medical report, there is no injury on his body, Your Lordship. So the FIR is at page 16, Your Lordship. May I read, Your Lordship?
Read
Oh,
what?
that's
Huh?
Yeah.
Where is the charge sheet?
It is as page 25, Your Lordship. Before that, Your Lordship, 21 medical report, Your Lordship. No bodily injury. Charge sheet as 25.
Charge sheet, it is written as per medical report. It is seen this case is established under so and so. So what is the medical report? Page?
Medical report is annex 21, Your Lordship. Page 20. Page 20. Your Lordship, type copy and the original at page 21. Abdul Rohim Sheikh, date and time of medical examination, nature of injury, no injury or abrasion found. Your Lordship. No injury or abrasion found, body ache over back and thorax and low back. The case is of 2018, Your Lordship.
E07 may not be attracted.
Nothing, Your Lordship. It is a counterblock because there was a case lost by us.
41, you don't need
Postcode.
injury for wrongful restraint.
That is there.
Wrongful restraint is absolutely false, Your
No,
Lordship.
false and all, we cannot decide.
And the examination, preliminary examination was done by the police investigating all the relatives of the informant. Your
But no compromise.
No compromise.
No.
my lord.
Hmm.
No compromise attitude.
Actually,
Marte dam tak.
Bate dam tak, my lord.
Lordship. That's why I am before Your Lordship.
But TCI is concerned, my lord, the witnesses, they have implicated these petitioners, my lord. They are eyewitness. Something has happened, my lord. Ultimately, it will be dependent on trial, my lord. But it has happened, my lord.
Thing will have trial, Your Lordship.
Legmark, my lord, Lordship may kindly go through one of the statements.
Your Lordship.
Charge was
Charge was
not
not
framed. It,
The stage of appearance, it
the
was
stage
there.
of appearance itself. By now, your trial would have been over.
Yes.
341.
yes, yes,
4 years have,
Yes.
5 years gone by.
5 years.
yes.
8 years, Your Lordship.
Even they could pray before, at the time of
They
charge.
prayed for
pray.
discharge
Yes,
at
discharge,
that time.
If there is no case, my lord, they can pray for teachers. Next.
It comes under
Falsity or otherwise, we cannot decide. We have to only see if there is
Yes, my lord, prima facie from the
prima
FIR.
facie something is made out or not.
Your Lordship, it may see whether it comes under the parameter raised by the Bhajan Singhs and Your Lordship.
Hmm.
Because
It
Two.
is what does Bhajan Singh say? No offense is disclosed in the
Yes.
face of the FIR, even if
Yes, my lord.
Not
taken at its face value.
Yes.
facie reveals the case, then not a fit case for question.
Where have you shown that it is actuated by malice or something like that?
Yes,
Where have you shown that?
I've said that it is a counterplot to our case, your lordship, clause.
Sufficient.
Yes, and
That may be good enough for bail.
page 13.
Yes.
Clause G, your lordship. For that the instant criminal proceeding is manifestly attended with malafide and has been instituted, page 13. Your lordship.
How? That is
With
what
an ulterior motive to wreak vengeance on the petitioner by informant against whom?
simply parroting Bhajanlal will not do. You have to satisfy.
The facts also reveals that we lodged an FIR that was registered earlier, Sukcha PS 72 of 2018. Thereafter, they lodged an FIR that is registered as 73 of 2018.
No, well, in your FIR, what is the date of your FIR?
My FIR. Date I have not mentioned, but it was apparently registered
It
before.
was before when date is not there.
Before, it is PS 72.
All right, but what is the allegation there?
Their allegation was that the informant and his son has assaulted my sister, your lordship. And the case was registered under section 120B, 341, 354, along with POSCO section 6. They were arrested and subsequently they are on bail. Immediately thereafter, perhaps maybe on the same day, they have lost the FIR. That was
Same
registered
day.
73.
Same day, 72 and 73.
73.
So
Perhaps
same
I
day.
don't know, your lordship.
Must be same day.
What had
Must
happened?
be arising out of the same incident.
Same issue. What
Cross
had happened?
case.
What had happened in this case, my lord, the father of the petition number 3 is a political leader, and the respondent number 2 is headmaster at that point of time. While the constituting the managing committee of the school, the father of the petition number 3 has dictated the respondent number 2 that without having any general meeting, as per his dictation, the managing committee president has to be selected. Then while he not abide by his dictation, my lord, when he went to his schools, at the time they restrained and snatched away the register and others materials from the headmaster. Then this assaulting was taken place. And thereafter the FIR, which my learned friend has relied, my lord, that was filed on the same day. But due to the political high-handedness, my lord, this FIR also has been registered, my lord. This is the factual part.
No, your lordship, nothing has been
So, my humble submission, since
No document
prima facie
has been
reveals the case,
regarding the snatching of any documents. They're absolutely false, your lordship.
You keep saying absolutely
Yes.
false. Who is going to decide whether
There
it is
is no
false or
seizure of
false?
those documents, your lordship. Nothing has been seized. Apparently, there is no seizure of seizing any documents.
Yes, snatched away. How can it?
Where the record is there?
Yes, my record is.
Victim state, I mean, any statement of
Witnesses,
independent witnesses is there.
I have flag mark.
My only humble submission that it comes under exception G of the Bhajanlal, your lordship. It was absolutely manifestly attended with malafide and malicious intent. Only as a with the ulterior motive to wreak vengeance on the petitioner by the informant against whom the petitioner and the family members have filed an FIR being Shukchor case number so and so and so, and also with a view to speed them with due to private and personal grudge.
My humble submission before lordship, if the thing is that they have ought to have been filed a research petition before the trial court. Trial court will decide.
Oh, if there was
This
any
prima facie
allegation
reveals
regarding
from
the managing committee,
affair as well as that.
managing committee, they would have lodged any complaint before the admission department, your lordship. Nothing there. Absolutely nothing. No complaint before the departmental authority. The dispute was regarding the school managing committee. They should have lodged a complaint.
All right.
Yes, much obliged.
Chief.
Much obliged.
Only my humble submission, your lordship may kindly take into consideration the exception, your lordship.
So that is what we have noted. We'll examine. We haven't decided.
May I please? This matter has arises out of a check dishonor case. The petitioner was convicted under section 138 and sentenced to imprisonment for 2 years and a fine of rupees 20 lakh. However, at the appellate stage, it was also upheld. And during this proceeding, it was amicably settled. Both the parties agreed at the amount of 10 lakh to be paid in 3 installments. First installment 4 lakh, which has been paid, and the 2 installments after 3 months each. So the compromise deed is at the IA at page 910. IA.
So you agree?
Yes, your lordship, we agree on that.
Huh?
My only humble submission is that let the matter be pending for 2 months.
Oh.
That they comply with the agreement.
Oh, you are afraid of that once it is quashed, they'll.
Yes, your lordship.
Let you let the payment be complete, then we'll see.
Can be kept pending, there is no problem, but there is no use of keeping it pending.
Learned counsel for the petitioner and learned counsel for the respondent is submitted that subsequent to the conviction of the petitioner under the provisions of the NI Act, the same appellate court also has upheld the conviction. Subsequently, the matter has been amicably settled between the parties, and the payment of the due amount is being made in installments, and accordingly, there has been made to list the matter after 2 months, within which the payment is expected to be complete.
No, the second installment will be completed. And
Then third, then
third
fourth.
installment after another 3 months.
Then
So that's why I'm saying. I mean, the condition is that first installment of rupees 4 lakh has been paid at the time of execution of the settlement deed.
what is the total amount?
Total amount agreed upon is 10 lakh. And second installment has to be paid at the amount of.
Anyway, all right, we'll see after 2 months what is your progress.
Yes.
Given that after 2 months.
Obliging.
Matter will be taken, lordship, after 5 minutes. Senior is an underline. I call. After 5 minutes, lordship. Please.
May I please, lordship? I am for item number 18, lordship.
18.
Lordship. Lordship, in this case, lordship, I have been behind the bars for last 5 months and 12 days, lordship, since 14 to 2026, lordship. Lordship, you kindly see page, lordship. Page 13, lordship.
What commercial quantity?
Commercial quantity.
Lordship, from my possession, lordship, nothing was recovered, lordship. Only mobile phone was recovered from my possession, lordship. And contraband, lordship, which has been alleged, lordship, were seized from the other 2 accused person, lordship. Lordship, kindly see, lordship. Page, lordship, 25, lordship.
Rontuali,
Lordship.
you are?
I am for Rontuali, Lordship.
Mobile phone.
Okay, sir. Only a mobile phone, one Realme 9 5G in the name of Rontuali. This article was seized and nothing else, Lordship. Lordship, even Lordship, Lordship, maybe please to see Lordship, page 14, Lordship, what is my involvement, Lordship?
Yes.
Page 14, Lordship, of the affair, Lordship.
Yes.
Lordship, I'm reading out the relevant paragraph, Lordship.
Yes.
During interrogation, the accused Rohimuddin Lashkar discloses the source of supply and led the police team to Jalukbari, where co-accused Rontuali, 34 years, son of Kadir Ali, resident of Swayanso, PS Kamalpur district, Kamalpur, Assam, was apprehended. Rohimuddin Lashkar was apprehended first, Lordship. On further disclosure of apprehended person, namely Rontuali, it was revealed that the codeine cough syrup had been procured from a pharmaceutical wholesale shop, namely Okula Pharma, which is situated at Adabari, owned by Manik Singha. He is one of the other accused persons, Lordship. And Rontuali, Manik Singh and Rontuali purchased the said contraband from there and distribute to Rohimuddin Lashkar. As per the disclosure of Rontuali, along with PS staff and apprehended persons, namely Rohimuddin Lashkar and Rontuali, went to Adabari to apprehend Manik Singha. Upon reaching at Adabari, Rontuali showed us the Okula Pharma from where he used to procure the NDBS substances. This is the alleged involvement in my name, Lordship. Since the date of Lordship arrest, Lordship, I have sufficiently been in the bars, Lordship. So on any terms and condition, Lordship, I may be allowed, Lordship. Section, Lordship, 20B small 2, capital B. Section 21 small b. Section 22 small c. These sections, in fact, Lordship, are not applicable in my case, Lordship.
Yes, prosecution.
Yes, Lordship. First, I want to state here, Lordship, the Rohimuddin from whom the 258 bottles has been found, Lordship. This is a commercial quantity. And then from when he was asked, he was said that he supplied from this Rontu Ali, Lordship. And this Rontu Ali then stated the name of the Manik Singha, Lordship, who is also a.
Yes, that we have understood.
Yes, Lordship.
Ultimately, you went to the pharmacy and there also 860
Lordship.
bottles were recovered.
It's recovered, Lordship. And again,
That's a different question, of course. It's a pharmacy. If he has the license to store, that's his issue.
that is a different issue, Lordship. But in this case, there section 29 is also there. So in his case, it is attracted, Lordship, as section 29 is also there. Moreover, Lordship, when the statement of this Rohimuddin, he stated in his statement, Lordship, that he bought it from Rontu. And Rontu stated that he stated from Manik Singh.
So it still remains only statement of co-accused, is it not? I think from your side, someone said yesterday or day before regarding that. Who was there? Was a discussion? Someone said some judgment is there. Yes. Bela Trivedi.
No, my lord, I'm sorry, it is by one is by my lord Indira Banerjee, my lord. Another by my lord Honorable.
Anyway, let's see what
Yes,
is there.
my lord. Just two judgments. Era 8. This is also a NDPS matter, my lord. Peruse from clause number 77, my lord. What may I read, man? What emerges from the record is that large quantity of contraband weighing such and such was found in a car which was driven by Zakir and whether the role played by said Zakir could get connected with both the accused is a question. The answer to said question could be the statement of the recorded under or record of Nizamuddin. The statement of Zakir recorded under 67 of the Act has also named his owner accused such and such. We are conscious of the fact that the validity and scope of such statements under section 67 has been pronounced upon by this court in Tufan Singh versus Tamil Nadu in 2001 for SCC 1 in the state by LCP, Bangalore and Prahlad Ahmad Arimuta and another. The rigor of law laid down in this court in Tufan Singh was held to be applicable even at the stage of bail. However, going by the circumstances on record, is on the strength of statement of Nizamuddin allegedly retracted later, the matter stands on a different footing. In our consideration mandate of 37 of the Act, High Court could not have ought to.
Here in the judgment, Lordship, the person from whose contraband was recovered, that he was the petitioner and his bail was rejected, Lordship.
Strength of co-accused, my lord, he was not released. Another
What law has been laid down here? Nothing.
there is not, but since the circumstances of the case, my lord, he was not released on bail.
In the circumstances of that case, that
Yes.
Vance thought it was
Because
stands on a different footing.
And here also, my lord, only what I want to show, my lord, that because of the fact that the 161, 67 statements were discussed, my lord, and one thing also discussed. Thereafter also it is rejected. So you may kindly see in the
Discussion is there, but
Yes.
reason is not there. Reason is that it stands on a different
You
footing.
may kindly come to the second page, my lord.
Is it said that the law laid down in Tufan Singh and this Amruta is incorrect?
No,
No.
no, that is that. My lord, in the second page, your lordship will found, my lord. Here, in this judgment. Second page, para third, my lord. The High Court has ignored the materials on record, including incrementing statements of witnesses under section 164, 161 of the Code of Criminal Procedure. Statements under 161 of the CRPC may not be admissible in evidence, but are relevant in considering the prima facie case against an accused in an application for grant of bail in case of grave offense. The High Court has granted the respondent accused bail without considering the heinous nature of the allegation against him, the gravity of the offense alleged, and severity of punishment in the event of ultimate conviction. Only because the co-accused has also been granted bail. In this case, the gravity of the offense is taken into serious note by the Honorable Court. So NDPS case now. Affecting the society at large.
Gravity, Lordship, gravity of offense may be taken seriously for those person, Lordship, from whose the contraband of a commercial quantity are seized. So that part may be taken, but the person, Lordship, who is before Lordship, nothing was recovered as alleged. Is very clear, Lordship. According to this judgment, Lordship.
The first judgment I given my, it is by Honorable CJI and Bela Trivedi. Yes.
That's the.
Yes,
okay,
Your
but
Lordship, I am
question
ready
is-
to abide by any terms and conditions, Lordship, if imposed by your Lordship. And Lordship, there is no any criminal antecedent in my name, Lordship. And moreover, Lordship, I am the permanent resident of Kamrup District, Lordship, residing at village Baregaon, Lordship, under Kamalpur Police Station, Lordship.
That is superfluous. Question is whether 37 will be attracted or not
Yes, ma'am.
because of the decision of the apex court in P. Krishna Mohan Reddy specifically dealing with this aspect of the matter, statement of co-accused. Where it has been very specifically, after discussing the entire gamut of the law, it has been held that even for the purpose of bail, regular bail as well as anticipatory bail, the statement of co-accused cannot be taken into consideration. So in this case, it has been said that they are relevant,
Yeah,
but
trial is proceeding, my
there
lord.
is
Now,
the
I on the trial, my
but
lord.
that can be treated as a ratio, binding ratio, because
Lordship,
in order to be treated as a ratio, there has to be the reasons also assigned.
Perhaps, my lord, in criminal appeal 938, my lord, there is some reasons. My lord. Second one, my lord.
No, we are referring to second
The-
one only. Second
the-
one, it says that it is relevant for the purpose of bail.
Lordship, trial is going to be started very shortly, Lordship.
Yes.
Lordship, keeping me behind the bars will not serve any other
What about
any
the other
further
person?
purpose, Lordship.
Yes, other. You are Manik,
Yes,
pharmacy.
Lordship. Lordship, matter may be adjourned for the day, as I will file an additional affidavit. Bring additional records, documents into record, Lordship. Lordship, as after Lordship has passed order dated 6/4/26, subsequent development was there, charge sheet was filed. In order dated 6/4/26, Lordship has directed the authorities to bring the percentage of the codeine of FSL. Thereafter, the charge sheet was laid, and we have filed a petition before the trial court, and trial court has directed the investigating agency. And that part of record will bring as an additional affidavit. Some time may be given. File the affidavit in the meantime.
Alright, so we can separate these two cases.
Yes, Lordship.
His case is slightly different. He is a pharmacy. He may be having
My
some.
contention is different.
Item 17 on the prayer of learned counsel for the petitioner is the matter again on in order to enable him to bring on record certain documents by way of additional affidavit. We are reserving order. We'll examine.
Deeply obliged.
Much.
Let's do one thing. 18. Since this you go through P. Krishna Mohan Reddy also
Yes.
and make your submissions.
Yes.
We'll fix it again on Friday. Inform the council he has left, I think. In number
17.
18, list again on Friday in on to enable prosecution to address the court on law points in the light of the decision of the Honorable Apex Court submitted today. 16. Okay. Yes.
May I please, Your Lordship? My lord, in this case, one issue is there that my appeal was decided ex parte, my lord, without there being any defense. On that ground, my lord, the Supreme Court decision in the Shukuralis case, where it says that ultimately the matter was remanded back, saying that if the defense counsel was not there, the court could have appointed an amicus curiae. I did not, when my counsel withdrew, I did not know. The court said that they have sent some notice, but I did not receive any notice, my lord. Can I just hand over the decision, my lord? So, without going into detail at this stage, I pray that your lordship may remand the matter back to the lower appellate court to decide the matter afresh, my lord.
Where is the judgment, impugned judgment?
My lord, the judgment is page 64, my lord. Page 64, it's none appears for the appellant. One Mr. Hawk was for the respondent.
You received the notice, then did not appear.
No, I did not receive any notice.
Court record shows.
Court said, my lord, but I as a appellant.
Paragraph 4, my lord,
I-
page 66. Findings of the court, my lord.
That is what we are saying.
Para 4.
Yes.
Thereafter, a court notice was issued against the appellant to engage a new advocate on his behalf, but the appellant remained absent despite proper service of court notice. But over here, that my plea is that, my lord, I did not receive any notice, nor I was aware that my engaged counsel has withdrawn. My lord, even for argument's sake, though I did not receive, that is categorical, my lord. But even if that was the situation, the Supreme Court says, my lord, then the court ought to have appointed an amicus curiae from the advocate side, from the advocate of criminal side practice, my lord. I think the main findings are paragraph 16 and 17 of that judgment, my lord.
Yes.
This judgment has been declared, my lord, as per inquiry by the Honorable Supreme Court, my lord. By subsequent.
Para?
Para 18, 19, 26, and 32, my lord.
26 আৰু
25%.
So Sukur Ali is gone.
Really gone, madam.
What remains? You can argue only on merit.
My lord, would your lordship be pleased to give sometimes, my lord? I'll just find out. I think possibly in 32, in what I've just had a glance, my lord, I'm not aware of this judgment. The para 32 again talks about that it's only case to case, my lord.
Don't see anything in paragraph 32 in your favor. Reiterates that Sukur Ali is par incuriam.
For inquiry. My lord, let it be after 2 weeks. In the meantime, I'll just somewhere I got this thing that possibly it cannot.
Here, my lord, the conduct, my lord, the appeal was admitted, my lord, subject to payment of 20%. That was also not paid.
All right, on the prayer of hard learned counsel for the petitioner who has placed reliance on the decision of the Honorable Apex Court in Muhammad Sukur Ali versus State of Assam, 2011, 4 SCC 7 to 9, to urge that the appeal ought not to have been decided in the absence of the counsel for the appellant and without appointing an amicus curiae. Para par contra learned counsel for the respondent has placed before this court the of the Honorable Apex Court in K.S. Panduranga versus State of Karnataka, 2013, 3 SCC 721, whereby the decision in Sukurali Supra has been held to be per incuriam. Para, learned counsel for the petitioner, seeks some time to address the court on the aforesaid issue. Accordingly, list the matter again on. Yes, give a date.
Published. That's not a linear. Linear. Judgmental later.
Table of Rahul division.
Up to the nine. But before the announcement start, my lord, here, my lord, PCR means up to, my lord, 17/4/26 only, my lord. Subsequent to that, my lord, it is not updated, my lord. Take, my lord.
The trial is ongoing.
Ongoing. My lord, perhaps, my lord, but I've checked the last date, my lord, I've flag mark also, my lord. 22, up to 22/4 actually.
What is this? NDPS? NDPS?
Kindly fix that date
Huh?
after 1 week. In the
Right,
meantime,
it is submitted that
DPS commercial.
the PCR is only up to
Up to, my lord, 17/4/26.
17/4/26. And learned PP praised for calling for the updated TCR, hence call for the updated TCR. List the matter again on.
kindly before, kindly a short date, Lordship. Before 15, Lordship.
All right, in between August 2nd week,
13 August.
Published, Lordship.
Here, Lordship, this petitioner was earlier on bail. Due to some communication gap between counsel and my lord accused, some days he was absent. So NBW issued, later on my lord PNA. Now on this 10th of that NBW, my lord, which arrested him on 1st of May, my lord, today 90 days he is behind the bars, my lord. He is ready to cooperate with the my lord case. Case is a evidence test.
Evidence test last order is of 14/7, my lord. It is fixed on 28/7 for evidence. Evidence perhaps not yet started. Evidence perhaps not yet started, my lord.
Although case is registered under 376, my lord, this is a case of 354. Nothing happened, my lord, only torn the process. That is the case, my lord.
As per 183 statement, my lord. That's the case, my lord. I have checked, my lord.
Oh, we are not on that merit now. We are
90 days, my lord, he is behind the bars.
third learned counsel for the petitioner and learned additional PP. PCR as called for has been received. The petitioner is facing trial in connection with what is the case?
Sessions case number 71 of
71
24.
of 24 pending before the court of the learned session Judge Kamrup Amin Gaon. The petitioner was granted bail, but subsequently he defaulted in appearance. and thereafter he was arrested on strength of NBWA. Since then, he has spent 90 days behind bars while the trial is underway. It is submitted that the petitioner shall henceforth regularly appear before the court. Hence, taking into consideration the period of detention, may be allowed to go on bail. Para having regard to the above, directed that the petitioner shall be released on bail of is 50,000 with 2 sureties of like amount to the satisfaction of the learned trial court. It is directed that henceforth regularly participate in the trial. Hence disposed of.
Please, Your Lordship. My lord, charge-sheeted case also is there, my lord. TCR was called for, that has been received, my lord, along with.
My lord, yes, my lord. PCR received, my lord. We have gone through that, my lord. My case is also present, my lord. Already.
Where is the FIR?
Right,
My lord, FIR is at page 18, my lord. Vernacular is at page 20.
Very, very good. So you can be.
Translated is in page 18 and vernacular is at page 20, my lord.
Your name is?
My lord.
Your name?
My lord, Indrajit Rajbangshi, my lord.
Indrajit Rajbangshi.
Solely case, my lord. Trial is going on. Informant has already been examined, my lord.
Yes.
I was arrested on 28th February, my lord, 2026, and today is 151 days, my lord. He is a student of class 8, my lord. And for my lord, the medical report, her age is 15 to 17 years. But her birth certificate, my lord, reflects as my lord 11 years, 8 months at the time of my lord parents, my lord.
Victim not yet recorded.
Victim yet not recorded, my lord. And my lord, in the my lord, date of commencement of the offense, my lord, she is my lord below 12 years, my lord. From the my lord date of the FIR also, my lord, on my lord 19th, my lord, when the my lord that is video was viral, that on that point of time also, my lord, below 12 years. And if it is taken, my lord, 7 years back also, my lord, 12 years. 183 statement, my lord, clear implications there, my lord. My lord, last date was fixed on my lord 23/7/2026, my lord. That is not available with us, my lord. Date of evidence.
That time, my lord, PO was on leave and my lord, PWS was also not found. My lord.
Medical report is not available.
That is available in TCR, my lord.
Medical report is also available, my lord. Because my lord, in the earlier, my lord, 7 years back, my lord, otherwise no, my lord, finding was there.
But extra is there, my lord, in the search sheet, my lord. Our medical report, my lord. That is page 28 of our petition, my lord.
What is there?
Page 28, my lord, our petition, my lord. In search sheet, my lord, the extract of the medical opinion is there, my lord. In search sheet, my lord. Appeals, my lord, there were no marks of violence on external examination. Internal examination, hymen was not intact. Tears seen at the position vaginal wall at 6 o'clock position and internal vaginal wall at 3 o'clock.
Medical also implicates you.
My lord, here, my lord, X-ray for age determination shows age is between 15 to 7 years. X-ray was awaited for a second time, which show the same age, my lord.
That will not come, my lord. That is settled by the Honorable Supreme Court.
And see,
Even if it is 15 years below.
Then also, my lord, minor.
then, my lord, the section 6 will not come, my lord. Then section 4 will come, my lord.
Law is very settled, my lord. When there is birth certificate, my lord.
Then also the section 6 will come. She said twice.
My lord.
My lord. There, my lord, the birth certificate is issued on 10th March 2026, which was subsequent to the incident, my lord.
That may be taken into account,
My lord.
but
My lord, another certificate is also there, my lord. Only the thing is that nowadays, my lord, to obtain, my lord, immediately, my lord, birth certificate. Now the government's, my lord, new rule is that you have to obtain, my lord, not, my lord, by handwriting, my lord, where there is a handwritten, my lord, form of birth certificate is not used. Because of that, another birth certificate is also there, my lord, where it is handwritten, my lord. It is, my lord, issued on that point of time. But they have taken, though, my lord, 2 numbers of birth certificate procured, my lord, date of birth same, my lord, only because of the today's
original handwritten is there. That is
Yes, my
issued in 2014.
Yes, my lord. No dispute, my lord, regarding the date of birth, my lord.
Lordship may also consider the age of the, my lord, accused person, my lord.
What is the next date?
It's the 31st August, my lord.
The victim will be examined on that day.
My lord, your lordship may kindly consider the age of the, my lord, boy, my lord. That is his date of birth as per registration card of class 9 is 13/8/2010, my lord. And the birth certificate also reveals, my lord, same date, my lord. That is annexed to page 13, my lord.
What, juvenile?
My lord, then it is a, my lord, juvenile, my lord. Yes, my lord.
Then,
If
my
it
lord-
is so, my lord, then it is a case of juvenile.
Then
Now,
it
my
is a
lord,
case
charge is framed. My lord may kindly produce the CW1, my lord, the register of the birth and date, my lord, where, my lord, learned trial court before, my lord, proceeding, my lord, he was examined as a court witness.
The court has already found he is not a
Yes, my
juvenile.
lord, not a juvenile, only because of that. And if that plea has to, my lord, defense has to take, then they can file it. They know it is not correct, and this is the, my lord, original date birth certificate, my lord. They can go for that, my lord. Otherwise, as part of, my lord, charge sheet, he is, my lord, his age is, my lord,
20 years.
yes, my lord,
That's 20 years, my lord.
20 years, my lord. And girl is, my lord, below 12 years, my lord. At the time of commencement of the offense, 11 years, 2 months only, my lord.
8 months.
That is,
It will not be safe. At least till her deposition is
My lord.
recorded, it will not be safe to release you on bail.
My lord. Then may fix another date, my lord, after 31st.
Submitted that the trial has commenced, but the deposition of the victim girl is yet to take place, and the next date is fixed on 31st of August. Is the matter again on
31st, after 31st August.
after 31st September,
Published.
3rd September.
well, updated, my lord, status report, my lord.
Trial court is directed to send the updated status report. Not status report, updated scan copy of the TCR. But we should, I think, the updated means after recording of the.
After recording, my
After
lord.
recording of
Yes,
the
my lord.
evidence of the
We don't-
victim.
This is regular bail application, Lordship. Lordship, the petitioners.
Instead of saying updated, say with send the scan copy of the deposition of the victim. That is all. That can be sufficient. Updated baki gotebilak. Before the next date fixed. Specific corridor before 3rd of September. Next day 3rd of September, right? 3rd of September. Yes.
My lord, and certain documents is I have to supposed to file lordship, and can it be day after tomorrow lordship, and certain judgment is also lordship? Otherwise the
The
petition
prayer of learned counsel for the petitioner lists the matter again on
Friday lordship.
Mandate.
it is received.
It is received, my lord.
Will it receive be retained till then? Yes.
On Friday lordship. Obliged lordship, deeply obliged.
It is not available, no? Okay, thank you, sir. Yes, CD is not received, my lord. I was praying for another date.
She did not received. IO has prayed for another date. List the matter again on next week.
Be after. Maybe next week. May I please, your lordship?
Notice is served.
Notice is not served, my lord. Not served. Able to serve, my lord.
How many respondents? POCSO case.
There are 5 number of complainant is there, and victim guard is also 5 number. Already
Kindly-
10 witnesses are examined, your lordship.
But you are a teacher or what?
The cultivator, government.
Kindly fix after 10 days, my lord. I will try to serve because there are several respondents.
Here is received, but service on the respondents 2 to 6 are not complete learned PP. Time to
12th of August.
take instructions. Just again on 12.
May I please, your lordship? Here 10 witnesses are examined, but I have not seen the record.
Not there.
It is not there. But
My record I have not checked, man, because of the notice. That record has to be confirmed.
Yes, it is there.
is there
Yes.
10 witnesses.
Up to 9 it is there. To PW 9 it is there.
But the 10 is there here.
Hmm?
10 has already been examined.
Okay.
Up to 9, I have an extra lordship.
Trial is already ongoing. Their counsel must be through.
5.
These witnesses have appeared. They
Yes.
have appeared
No.
through the. You can contact through the court.
Because
Even their evidence had gone back. Nobody from the court will be in contact there.
my lord, as per procedure, my lord, the notice has to go for the IO, my.
Obliged.
Twenty-seven minus succeed it might.
This is the offense. POCSO.
But 48 and 36 has not complied, madam. Your lordship, I have annexed the 48, page 21. It was served upon the accused. It ought to have been released, relatives of the accused. But it was addressed to Shiabuddin father, but served to the accused.
All right, we'll examine scan copy of
So
TCR.
that may be observed kindly.
Is to be observed. Will you
But
not be
your
there?
observation will get the consideration. Otherwise, your observation will get some consideration in the court below.
We are
Otherwise,
not
it will not
disposing,
consider.
we are calling for scan
Want to
copy.
appear before
You
the-
want to appear?
I'm behind the bar.
You want to, acha, you want to approach that court by way of bail application?
This is the charge sheeted matter, that's why.
Uh,
Otherwise, your lordship can grant the bail. I have got no there. I rather I will be to be present on my
we
part.
we can't
But-
run the bail without the record.
48 has not been followed.
And that is why we need the record. If you want to appear there, we'll observe. All right. Mr. S.C. Biswas, learned counsel for the petitioner. Learned additional PP submits that charge sheet has been submitted by
Right,
CNC.
number 35/26 dated 35/26.
For the petitioner that the provisions of, what is violated? 47, 48.
No, 48 and 36.
Provisions of section 36 and 48 of the BNSS has been violated, which entitles the petitioner to. However, since the record is available only before the learned court below, the said aspect of the matter can be examined by the said court. The event a bail application is preferred by the petitioner, the said court. Accordingly, this bail application stands disposed of with the observation that in the event the petitioner approaches the learned court below appropriate application, the said aspect of the matter will be considered with the learned trial court. Petition stands disposed of accordingly.
Twenty-eight also minus succeeded might.
PCR has come, lordship,
Oh, PCR.
but lordship, so far as
Service
Service
report is
upon-
not complete.
respondent number 2 is concerned yet to
Not yet complete, might.
not yet completed upon this. If lordship appointed amicus curiae, then hearing may be completed, lordship. He's behind the bar more than 8 months, lordship.
Third, learned counsel for the petitioner, learned additional PP. And copy of TCR has been received. And it appears that the victim and her mother has already been examined. Also, however, notice on the respondent number 2, informant is not yet complete. Notice you took steps through what?
Oh, resta post, lordship. No PP.
Already. Learned additional PP to in instruction regarding service of notice. You have not received any instruction.
No, might not received. Action regarding report, my service, might.
In the meantime, considering the period of detention of the petitioner for more than 8 months, this court deems it fit to appoint an amicus curiae to represent the respondent number 2 in the event notice is not complete even by the next date fixed. Accordingly, it is amicus. Thomas. List the matter again on.
Before 15, 15 no. Instruction. Overlay.
Wait, please, Lordship. Lordship, this is NDPS commercial quantity, Lordship. Lordship, kindly come to the page number 14, Lordship. FIR, Lordship. Middle of the first paragraph, Lordship. Is at
Page.
page 14. 1-4.
The CD is there.
Scan copy, Lordship.
Yes.
Yeah, Lordship, this is in the middle of the first paragraph. It is written at about 12:50 p.m. Both the vehicles were spotted coming from Dimapur side towards Nagaon via Khatkoti and were signaled to stop. And this is the apprehension time, Lordship. I was apprehension at 12:50, Lordship. Then, Lordship, kindly come to the page number 30, Lordship. The arrest memo, Lordship.
Yes, what happened? Your name is?
My name is Zakir Hussain and Sanjeev Roshan. Then, Lordship, in the page number 30, I was formally arrested on the next day at 10 a.m., Lordship. Page number 30 and 32. Date and time of
You were arrested. You were arrested with the vehicle.
Yes, Lordship. On 26th, Lordship. I was apprehended on 25th at 12:50 p.m. And I formally arrested on the next day, 10 a.m., Lordship. Then, Lordship, kindly come to the number. Page number
Where is the time shown? Page 30.
Page 30, Lordship. Page 30.
Page 30, time is 26/3/26 at
Yes.
10 a.m.
Yes, Lordship. 10 a.m. This is the formal arrest timing. Then, Lordship, kindly come to the page number 29, Lordship. This is the medical examination report, Lordship. Whereas I was medical examination.
4:25.
Medical examination was conducted at 4:25 p.m., Lordship. Then the last one more page, Lordship, for this is very relevant. Page number 10, Lordship. Page number 10, on top of the left side of the page, Lordship.
Page?
Page 10, Lordship. The printed form of the FIR, Lordship. Lordship, this I was produced before the magistrate. This 4:35 p.m. This is the receipt time. Time is mentioned there in the left of the FIR by UBC Bishwajit Talukdar. So my production time is 4:35 p.m. Lordship.
So 12:50 to 12:50 is 24 hours. If 1 hour is added for traveling, 1:50 p.m. Then 1:50 to 4:35 p.m. I was kept in illegal custody, Lordship.
I am not following. You say it is arrest is 26/3/26.
No, Lordship. I was apprehended on 25th.
Where is that?
Page number, this is 14, Lordship. Lordship. Page number 14. Paragraph. FIR was lodged on 25th.
Lordship may also look into page 17, Lordship.
Where is the seizure list?
Seizure list was not given, Lordship. Yeah. It may be in the scan copy, Lordship.
At 1:47 p.m. to 3:11 p.m.
Huh?
Lordship, the seizure. I'm talking about in the scan copy, Lordship. Date and time of search and seizure. 25/3/2026. This is the date. And the time is 01:47 p.m. to 03:11 p.m. 3:11 p.m. From 1:47 p.m. However, if you look into the FIR, Lordship, it is from the FIR, from the date on 12:02 p.m. information received, and 12:50 the vehicle stopped. And if you look into the page 17, Lordship, the second paragraph, it is stated that after completion of all formalities at 3:30 p.m. After completion of all formalities, I, along with team, departed from the PO, place of occurrence, at about 3:30 p.m. towards Gauhati police station, along with the seized item, and apprehended accused persons at 3:30.
3:30.
And he was produced at 4:45.
No, 3:30 is after completion. You
Lordship.
started the seizure proceeding at 1:47.
Lordship.
So by that time you had them in custody.
Lordship. It has to be also be.
Yes, Gauhati to where? Diffu.
Diffu, Lordship.
So 1 hour in travel time, maybe.
1 hour, Lordship.
1 hour at the most.
So that also be taken into account. That also needs to be taken into
So
account.
even that 1 hour has to be counted from this 1:47.
2:47.
3:11, Lord.
No,
Or at the apprehension.
because the law says only time of travel, not time for effecting the seizure. That requires a correction actually, but sometimes huge quantity, whole truck, whole night may be required or whole day may be required for that purpose. But still, police should be vigilant. I don't know when it will dawn upon Assam police that merely showing the time of arrest in the arrest memo will not be taken into account by the courts. It is the time of actual effective detention that is. But the highest. Don't suppose the message has gone down as yet, despite so many orders passed by this court. Oh. Yes. Pass orders.
Obliged.
Did you ask call for that? क्या है ना नहीं
Not available.
Not available.
But 2 hour information, it is charge sheet and matter.
We have not received any
Verify.
thoughts.
You're sure?
Yes, madam.
Okay, at your risk then it is submitted that charge sheet has already been submitted in the case. So what do you want to do?
From the client's information, madam.
No, you want to appear there.
Have to. I'm behind the bar. I'll appear. Madam.
Submitted that petitioner shall file a application before the learned court below. So hence this petition is disposed of with the observation that in the event such application is filed, the same shall be considered and disposed of as per law. Petition stands disposed of accordingly.
31.
31 and 32 may be passed over for the time being because it has been undergone by Mr. Parasalos.
Otherwise, my lord, petitioner counsel was there, my lord. He may not aware, my lord. Once he came, my lord.
Yeah, after some time. 34 to কি হল নাকি তো অর্ডার হল নাকি হ্যাঁ Governor gone through 34. Huh?
After some time, my lord, Esmonid is coming. 34. 34 months.
May I please, your lordship? My lord, the petitioner, my lord, was arrested on 5/6/2026, my lord. My lord, allegation is that, my lord, I was, my lord, carrying 4 numbers of kettles, my lord. And during transportation of the 4 numbers of kettle, my lord, I was arrested, and 4 numbers of kettles have already been, my lord, seized, my lord. And I am the owner of that vehicle, my lord, come driver, my lord, but not owner of the, my lord, kettle, my lord. At kettles, my lord, belongs to one, my lord, Momat Ali, my lord. He
hired my vehicle, my lord. And I have annexed the receipt also, my lord. So these are not stolen, my lord. That is, my lord, proof by the my lord receipt, page 22.
So how many days behind bar?
My lord, 54 days, 60 days offense, my lord.
Third learned counsel for the petition and learned additional PP and application under dated 13/7/26. TDS call for has been received. Is submitted that the petitioner is the driver cum owner of the vehicle, but not of the seized cattle. Also submitted that the cattle are not stolen and support of said contention, certain receipts have also been annexed. That as it may, having regard to the fact that the petitioner has spent 54 days behind bars, the payer for bail is allowed 50,000 to sureties.
'37, my lord, POCSO matter, my lord, and notice was issued to the respondent. But
CD also not received, my lord. CD and notice, my lord.
I have already taken a step, my lord.
This on respondent number 2 is not complete. CD is also not received. Is the matter again on
23/6 of the school.
20.
Published.
May I please, Your Lord? Lord, 483 bail application, my lord. The associated matter, my lord, the TCR was called for and it has already come, my lord. The petitioner has been arrested on, my lord, 25th of May 2026. As on date, he is behind the bar, my lord, for 61 days, my lord. Although search has been submitted, my lord, the trial has not commenced, my lord. Because as on date, my lord, the charges are yet to be framed, as I have the instruction, my lord. So your lordship, FIR will find your lordship at page number 11, my lord.
Yes, read.
My lord. Submission is that on 6/5/2026, while my daughter, namely Aklima Khatun, aged about 20 years, was coming back home from Santali Ansali College at about 3:30 p.m., the aforesaid accused induced her daughter from Pub Mahasara Road on a false promise of marriage and took her forcefully to some unknown places and kept her under confinement. Later on, I came to know that the accused has a wife and 2 daughters since earlier. Thereafter, we requested petitioner's guardian to recover our daughter and hand over her to us, but they did not hand over my daughter, although they undertook to do so today or tomorrow. Thereafter, on 25/2026, while the accused tried to flee after leaving my daughter near our house, he was apprehended with the aid of the public, and thus we recovered our daughter from the accused. I came to know from my daughter that the accused has forcefully committed rape upon her. Awaiting justice from the guardians of the accused resulted in delay in lodging the FIR as they assured to do so. So this is the facts projected in the FIR, my lord. In fact, my lord, the incident did not occur on 20th of May, my lord. In the month of April, my lord, the victim, my lord, voluntarily went to the house of the petitioner. Then, my lord, she was handed over to the guardian in presence of the police in the month of April, my lord. But in between, my lord, they bargained for some money and or threatened them of, my lord, the prosecuting with the false cases, my lord. Accordingly, when they did not concede to the demand of their money, my lord, that the affair came to be lost, my lord, after 1 month of the, my lord, the incident that was in the month of April, my lord. So subject to the material, my lord, in the case diary, my lord, in the record, my lord, TCR, my lord. My humble submission is that, my lord, that
What is the name of the victim?
Victim is Aklima Khatun, my lord.
Monica.
Monica is the, my lord, informant. Malika is the informant, my lord. She is the mother.
No,
She is a 28 years of girl, my lord.
victim. Aklima.
Yes, it is there, my lord, in the very second line, my lord. The simple submission is that on so and so, my lord, while my daughter, namely Aklima Khatun, aged about 20 years, my lord. She is a college going girl, my lord.
And it is not possible that, my lord, that she was coming back home, my lord, and on the road itself, my lord, she was induced for marriage, and then she was picked up, my lord. That cannot be possible, my lord, if they had not been in relationship with the, my lord, petitioner, my lord.
He's already married, my lord.
It is admitted, my lord. I am
Two
married, my lord,
children,
and I
sir.
have 2 daughters also, my lord. But the question to be considered by your lordship, whether a girl of 20 years, my lord, cannot be picked up from the, kidnapped from the road, that through instantly, my lord, on induce of marriage, my lord. That points are to be considered by your lordship. Otherwise, my lord, that would indicate that she was in relationship, rightly or wrongly, my lord. And if she is in relationship, my lord, and that she is a major girl of 20 years, my lord, so she voluntarily entered into the relation, my lord. So there is no force, there is no inducement in this case, my lord.
Case is under, now charge sheet has been submitted under.
My lord, I do not have the copy of the charge sheet, my lord. I also applied for, but that was not endorsed, and therefore I could not collect. It would be there in the, my lord, TCR, my lord. However, my lord, they allege that, my lord, the incident took place on 20,
How long you are behind bars?
my lord, 41 days, my lord. 41 days, my lord.
41.
41 days only.
I am the permanent resident of the locality, my lord. I face the trial and prove my innocence, my lord. And my lord, even another aspect to be
She
considered.
voluntarily went as per her statement. It's 20 years.
My lord, she went because, my lord, she do not know that he is a married person, my lord. After going there, she found that he is a married.
There is no
Interestingly,
kidnapping. Kidnapping is not there.
Exception is there so far, my lord. 69 is concerned, my lord. My lord.
Learned counsel for the petition, learned additional PP. Application under so and so. The allegation for the FIR is that the petitioner had kidnapped the daughter of the informant aged about 20 years, 6/5/2026, and kept her in an unknown place and committed forcible rape upon her. The victim was subsequently recovered. Learned counsel submits that the victim was in a love affair with the petitioner and had voluntarily accompanied him. And the informant side had demanded money from the petitioner. On refusal of the petitioner to pay the same, the FIR has been lodged after 1 month of the incident.
my lord, after 16 days, my lord.
For 16 days of the incident, where perusal and copy of the TCR appears from the statement of the victim herself that she had a love affair with the petitioner for the last 3 years and had voluntarily accompanied him. The recovery, the victim refused medical examination. having to the above, as well as the period of detention of 41 days. Further detention of the petitioner is not considered necessary. Further, and also the investigation of the case is over. Bail is allowed. 3,000. We'll see this.
I'm obliged now.
May I please your lordship? Lordship, it's a regular bail application and I am appearing on behalf of Shalimuddin Loshkar in connection with special NIA case number 29 of 2025 arising out of Shunai PS case number 40 of 2025. The allegation against me is that fake currency notes were found in my commercial vehicle. Lordship, the FIR is in page number 16. Lordship, may I read the relevant part of the FIR?
Kindly take it up after some time and inspect the LCR, my lord, because perhaps it will be required, my lord, regarding.
It is there.
LCR is there, my lord. Not go through, my lord.
Obliged, my lord.
See, here also, my lord, case has come up sometime, my lord, regarding the co-accused statement, my lord. Lordship has fixed 31st, my lord. Take my submission, my lord. So can be also fixed on 31st, my lord. Same matter, my yesterday it came, my lord. That part, because I have submitted the judgments on that.
Lordship, there has been fixed, lordship. 18-year-old boy, lordship.
Huh?
It's an 18-year-old boy, lordship. There has been fixed, lordship. They were supposed to give two judgments.
Already day after tomorrow, we have fixed it.
Yes, definitely.
The other involving the same issue.
Monday could
Submitted that
Monday.
matter involving similar issue has been fixed on 31st. Similar law points has been issued on fixed on 31st.
Yes, Lord, please go ahead.
Hence list this matter again on 31. Along with, do you have that case number? Item 17 something, I think. Item 17, I think.
A number 973, 2020.
18, yes.
In manner.
Along with 9.
31st also.
This one, ready.
May I please, my lord? My lord, I am long in custody, 59 days till today, lordship. Phase 14, lordship. Phase 14, the ground of the arrest, lordship. Ground number 1.
64, my lord, search sheet laid down, my.
Search sheet. Last date. As per order, lordship, the issue call for.
I seen.
No. Issue to as per order list.
Not received, my.
Then listen. With all respect, lordship, page 14, then listen. The ground of arrest, lordship. May I read this? Paragraph number 1, lordship. That on so-and-so dated, acting upon credible source of information, a search was conducted at accused residence situated at Vasabari line the Sinamora Jorhat after the observing the prescribed legal formalities under this NDPS Act. During the search of 12.8 or 12.82 grams of the suspected heroin, including plastic packet and excluding soft box, was recovered and seized from the jacket kept inside the house of the accused person, namely Soribuddin Rahman, alias Tetra. Not from me, not from conscious possession, from me, Lordship. Is kept in my residence house, and another is co-accused person, my sister Sennas Begum, was granted bail. A co-accused without call for CD, Lordship. And now I am in 59 days in behind the bars, Lordship.
Where is that order?
Order I have annexed, Lordship. The page 16.
Is intermediate quantity.
Yes, intermediate quantity.
So charge sheet submitted already.
Charge sheet submitted, but that is why my lord TCR has been called for, my lord.
But as
Today
per,
it is today.
Where is the order?
order, Lord, page 16. Page 16. This granted bail by another co-accused person, Lordship.
Sister.
Yes, Lordship. Not from recovered from this my house, Lordship.
Yes, recovered
Anybody
from
kept
your
in-
house.
Anybody person kept in my house, Lordship. This is the gave suspected, Lordship.
Something is recovered from your house, you can anybody can keep it. What is that?
Definitely, Lordship. As
Is
per
it a public place?
FIR allegation, Lordship. FIR
Is
allegation,
it a
Lordship.
public place?
No, Lordship.
Is it a
That
case
is-
that
that is
every
true, this is my
public
house,
come
Lordship.
and go and to your house without restriction?
And on that point, and another point is, Lordship, the page section 48, this I have annexed, the page 18, the section 48, 47 of the BNSS notice, the clear violation, there's no any particular details before arresting me. And now, all ground of arrest, reason of arrest is forwarding the post arrest, not PRS information, Lordship. Page 18, section 47 notice, Lordship. Only my name is there, mobile number is there, residence, nothing. The ground of arrest, reason of arrest. It's a clear violation, Article 21, Lordship. Now, Lordship, another co-accused.
So you are charge sheeted in 2 other cases. Are you aware?
No. This is I know.
You are not aware.
Lordship, not aware.
So you have not read the forwarding report.
Yes, Lordship. I have read the forwarding report,
You
Lordship.
have taken us to page 14.
Page 14, yes, Lordship. The ground of
Read
arrest
below.
and reason of arrest.
Read down below.
That is mentioned, Lordship.
Read down below in bold.
Item 2, clause 2,
Clause 2.
down.
In view of this section, so in number say so and so, my please not be released bail the previously arrested charge sheet in so and so connections with case so and so.
Habitual.
Release on bail, but not convicted at this stage, Lordship. So going on trial, Lordship. After filing of the charge sheet, Lordship, no further custodial detention, Lordship, is required, Lordship.
Was recovered from his house. He has absconded, my lord. It was recovered from his house. He has absconded. That is why his sister was caught. The sister was given the bail, my lord. Now he is absconding, and your lordship has just pointed out, my lord. He is earlier criminal antecedent also, my lord. So later, if lordship,
No, what do you mean absconding? He's in jail.
no, my lord, he first, my lord, as per the FIR, my lord, and when the recovery was there, my lord.
Now,
It was
this
for-
present petitioner
So later, LCR
belonging
will
in
be there,
Gauhati district. It's a totally flood affected area, this present person, lordship.
So where will you go? Stay in jail. Free food. Everything
This
is
is
there.
59, with all respect,
Hmm.
59 days in judicial
Your
custody.
condition will be
Further
worse if you are
detention.
released.
Why custody is necessary, lordship? Already search sheet submitted. Will appear before lordship, trial court lordship. And my sister released on bail only 12 days or 15 days. And I'm in long in custody 59 days, lordship. And till today, there's no any receipt the TCR lordship. With all respect, any term and condition may be released on bail, lordship. Will cooperate in face the trial, lordship. And petition is not a flight risk, lordship. It's a local person, lordship.
Go back to the same thing. You are you are habitual.
Which?
For you, your sister had to go to jail. I will wait for the TCR next week. Yes.
Short date may be given, lordship, with all respect, lordship. May I request, lordship?
Yes, next case.
Master group even fifth. Deeply obliged, lordship.
483 application, lordship. The TCR was called for another day, your lordship.
TCR received. I have gone through. TCR received, I have gone through.
Yes. What is there?
Fact is that here, though 10 of POCSO is there, 183 and 188. Both the statements, my peruse, there are differences, 183 statement and 187. In both the statement, there are differences. 183, she has not said nothing, madam.
One 183 says nothing. Learn it. How many days?
89 days is on today.
Huh?
89 days is on today.
89.
First is 1526.
Learned counsel for the petitioner and learned additional PP also heard learned counsel. As for respondent number 2, an application under so and so. As per the allegations reflected in the FIR, the petitioner used to touch the victim, touch the private parts of the victim, and also made her do so. Full stop. PRS called for has been received. Appears that statement before the magistrate, the petition victim has not implicated the petition. Further, has already spent 89 days in custody. Few of the above, the prayer for bail is allowed 50,000 to securities. Lordship.
As per notice, office note dated 27/07/26, service report is not yet received.
Complete.
No, not received.
Sure.
We'll take instruction, my lord. We'll take instruction, my lord.
Service report not yet complete as per office note. Learned additional PP to take instructions. TCR already received. Please again on.
Obliged, lordship.
Fair play, Your Lordship. It was a commercial quantity where on the plea of beyond 24 hours, Lordship. We have checked the TCR, Lordship. They asserted in the seizure list, Lordship, the time has not been mentioned. So may I pray, Lordship, the copy of this case diary might be necessary to ascertain the time, Lordship.
It is not there.
It's not there, Lordship. We have checked out the TCR, Lordship. There, Lordship will find the seizure list, Lordship, but that does not reflect the time, Lordship. Only date reflects the date, Lordship. Whereas in the FIR,
For
Lordship,
the petitioner, it is submitted that the case diary would be necessary to ascertain the time of the seizure. But the same is not available with the TCR. To produce the case diary on the next date fixed list again on.
much obliged, Your Lord. Much obliged.
May I please, Your Lordship? 8. But in this case, CD was called for. Earlier, Lordship was several occasion, Lordship CD was called, although I am in interim. Kindly peruse the previous orders. The CD has not come today also.
Based on an interim, CD is not able.
Carry on. CD not received list again on interim to continue. Date of listing.
My lord, I am appearing for item number 40. The petitioner is on interim bail, my lord.
CD not available, Lordship.
42, two is also for, you are in 41.
Number 40.
40.
She might be for 41.
Yes, lordship, I am.
Both on interim?
Yes.
Interim.
Both are in interim.
It's not received, same order. Yes,
Item number 40, I'm appearing for the MI.
all right, that's it.
Obliged, your lordship.
May it please your lordship. Your lordship, we are on interim protection and thereafter we have appeared before the IO. CD was called for.
CD not, CD was updated, sent back for updated, Lordship, update. But we have not received the updated CD.
Received back after it was sent back for updating list again on so and so interim passed earlier to continue.
Deeply obliged.
That please, your lordship. Service is completed, lordship. Last occasion, lordship, the service is completed.
Service on respondent number 2 is complete.
Yes, complete, my lord. CD also received, my lord.
CD has been received, none appears for the respondent number 2 accordingly. So and so appointed as amicus to represent, copy be served upon.
PROCEEDINGS is here.
T Parasar, yeah.
On Friday, lordship, CD is here, lord.
All right.
Deeply obliged, lordship. Obliged.
Pass over.
I was granted the privilege of ad interim bail, my lord. I appeared before the investigating officer.
CD has come.
Yes, my CD has come, my lord. He has appeared, my lord. The case is that he has made viral some of the photographs and video of the victim, my lord, on the internet. While his my lord, statements were recorded, my lord, he has stated that there is a love relationship between them and it turned sour. And thereafter, my lord, out of anger, he has made those video viral in the internet. This is his
That is the case, my lord.
own admission. my lord.
We stated everything on day one, my lord. That in anger I did it. Thereafter interim was granted. We appeared, my lord.
Offense is made out, my lord.
Has anything been seized?
Mobile has been
Yes,
seized.
mobile has been seized.
And to FSL, my lord, at that point of time. my lord.
For extraction?
For inspection, my lord.
No, anything recovered from that? But you admit
Yes, 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 my lord.
that you
I
have
stated everything honestly, and
admitted,
thereafter
my-
interim was
He
granted.
has admitted. my lord.
What is the subsequently filed this withdrawal application also?
My lord, the lab relationship, my lord. One affair withdrawn, thereafter again, my lord, some tussle, my lord. Then affair, my lord. And here all sections are available except one, my lord. 67A, my lord. And there has to be, my lord, sexually explicit act, my lord. Possibly those parts are missing, my lord. I didn't say, my lord.
For the petition. This is an application, so allegation against the petitioner relates to circulation of some videos of the victim in the social media. Appears from the material available in the CD that the petitioner and the victim were in a love relationship, which fact is reflected in the FIR as well. And due to certain differences that developed between them, the petitioner had resorted to the aforesaid act out of anger, which is not denied by the petitioner.
That is the admission, my lord, on it.
All right.
That is the
Because it is
admission.
your submission. You said we submitted.
Possibly may have did it, my lord, but if I say, my
Right.
There is one part. my
That
lord.
may affect trial.
one
It may affect trial.
May, my lord.
What is his age?
21 years, my lord.
Student.
Student man.
There is a student of 21 years. Para pursuant to interim protection granted by this court, the petition appeared before the IO and his statement has been recorded. Para, in view of the above, the custodial interrogation of the petitioner may not be necessary.
Also, may I kindly record my submission also regarding the materials in the CD, my lord, that he is admitted to what he has done, my. And also,
It appears from the material available in the CD, that part. After that paragraph, you add learned additional PP submits with reference to the CD. The petitioner has admitted.
My lord.
In the interim, my lord.
Admitted in the interim means?
In the interim, my lord, while he has recorded the statement, my lord.
Admitted before the IO.
I.
About his involvement. Interim prayers dated 2/6/20 made absolute. Is further provided that the petitioner shall not try to intimidate or influence the victim or the witnesses in any manner. Petition stands alone accordingly.
Highly obliged, my lord.
Give us full follows. Well, charge sheet submitted.
Is the offense?
Lordship.
POCSO. Scan copy. Your phone appeared. Okay. But learned counsel for petitioner and additional PP as well as amicus submitted that CS has been submitted.
CS number, my lord. That's it. 116/2026, dated 17/7/26.
Call for the scan copy.
I'm absent.
It's a substitute case, my lord. However, my lord, teacher has been received, my lord. Under section 1091 and 1182, my lord. Now, there are some minor types to place, my lord, and both the size, my lord, sustained from minor injuries.
109 is there.
109, 108, 118.
But I'm sorry, my lord, I have not gone through the TCR copy. My lord. TCR is available, my lord. How many cases, my lord?
Huh?
It's sorted, my lord.
Injury parties, my lord. My lord, there is no grievous injury, my lord.
Sheet also, my lord, under section 1182 and 109.
Yes, in this charge sheet, it is reflected injuries sustained by the victim were grievous in nature and caused by sharp weapon.
But there, yes.
You were saying it's not grievous. Go through.
My lord,
I could not find the medical report as such.
Fine.
Maybe it is here because many of them are in duplicates and wastage of time.
Next week, any date, my lord? Next week, any date?
All right, someone give another date. When?
Next Tuesday.
Next
Fourth, fourth.
Or if you want to see now also, you can take some time and see
Okay,
instead of leaving it.
Okay, my lord.
Tuesday, madam.
Tuesday. Learned additional PP. Press for some time to go through the PCR. Is the matter again on.
Diploma.
May I please your lordship? Lordship, it's a regular bail application. And I am appearing on behalf of Shalimuddin Lashkar in connection with special NIA case number 29 of 2025 arising out of Shunai PS case number 40 of 2025. Lordship, the allegation against me is that fake currency notes were found in my commercial vehicle. Lordship, the FIR is in page number 16.
But without going to the merit of the case, my lord, first, my lord, this BA is not maintainable, my lord. I just, if I show your lordship, my lord, then he can go to the merit, my lord. My lord, this is as per the schedule of the, my lord, NI Act, my lord, under section, schedule, my lord, here, my lord, 498, earlier, my lord, 489A to 489E. These are has to be governed by the
Legal
NI.
offences, huh?
Now 489A, B, C, D, E, all are malad 178, 179, 180 and all this malad, up to 182. And this case is booked under section malad 178, 179 and 180. Now malad kindly peruse the rejection order malad. Rejection order is page 28 by the special NI Act. NIA code. Page 28 malad, except 5. Bail was rejected by the NIA court. Malad. Now, there is a bar under section 21 of the NI Act, Malad. I am reading slowly, Malad, that 21A and 21B.
Appeal will lie.
Appeal will lie, Malad. 21 not anything contained in the code, and appeal shall lie from any judgment, sentence or order not being the interlocutory order of a special court. Here the special court. And before the, as per 21(2), appeal by the division bench, Malad. So, Malad, BA is not maintainable, Malad. To that extent, Malad, in earlier cases, Malad, coordinate bench, Malad, passed orders, Malad.
Yes, we are aware of that. What do you say?
Lordship, kindly consider the length of detention. I have been behind by from last.
We are on legal submission. We are on the jurisdiction point.
Para 7, Malad, of that judgment, Malad. Justice In that case, keeping in mind regarding the limitation period, just Senator Honorable Chief Justice consider to convert this case as a appeal. Has to become.
This order is dated when?
This order is dated,
24/4/26.
Oh, yes, ma'am. Present.
Limitation is 30.
Limitation is.
How many days? Limitation is?
Limitation, 30 days.
30 days, I think.
I'm not sure regarding limit. I do. Appeal 30 days. 21. 30 days, my lord. Provided the High Court may entertain the appeal, expiry of the said period of 30 days. Yes, 30 days.
So you can file an appeal with condonation of delay application. Or if you want, you can file another application, get it rejected and file. What do you withdraw?
What should I will withdraw it?
All right.
With liberty of the.
It appears that the present bail application is not maintainable in view of section 21 of the NI Act. Hence, learned counsel for the petitioner praised for permitting him to withdraw the case with liberty to approach the appropriate forum by way of appeal. Accordingly, the appeal stands, the application stands dismissed on withdrawal.
Oblige my.
May I please, your lordship?
In this case, we have filed one objection. I think it is in the record, madam.
If I am on interim bail, lordship, CD was called for.
Not received.
Please complete, Khali.
No, service. Take it, sir, if you are, sir.
CD has not come, madam.
CD not received, list again on. And so. Very impossible to continue to the next date of listing.
Oblige, your lordship. Oblige, your lordship.
27 August.
Please, your lordship. This is a second bail application, minutes. Earlier, I had approached this court and to disposed of because the case was charge sheeted. But now, lordship will find that bail order at page 42 minutes. It is observed that case I have to approach the trial court, special court matters, and then I had appeared before their matters, and then that order was bail was rejected, matters. Now my ground is, the trial is progressing very slowly, and there's charge sheet lordship will find there are 7 witnesses, 3 have been examined till now, till today.
Only 4 left.
4 left, but 4 have not come, the manner, because lordship will find at page 52. Entire history of that case is this, that many occasions, they have failed to turn up. And the next date is fixed on 10/8/2026. But call for the TCR also. So there are other grounds which have been inserted in the petition. I'm not pressing those. Teaser witness has been on 12/7/26. Teaser witness was examined.
No, whatever be, trial has just commenced.
My lord.
Cannot say trial is pending for 4 years, 5 years.
No, that I'm not submitting.
So, so what is the ground now?
My lord, that only 3 persons have been examined till now, my lord. The history of that case history I have annexed to my lord. On many occasions I have failed to turn up, my lord.
Turn up for how long? 2 months,
Lordship,
3 months.
my lord. Lordship may then post it after, my lord, that date, my lord, on that 10th.
What will happen?
If 10 something, nobody, my lord, Lordship can at least consider that aspect, my lord. I'm in custody since 9/8/25 minutes.
Come back after 2 years.
My lord.
You are not convicted by then.
My lord. That's a different aspect, my lord. It will be a year, almost a year now, my lord. If I cross, because I arrested on 9/8/25.
Commercial quantity, is
Commercial,
it?
commercial. That is
Then
admitted. That is admitted.
what are you crying about?
My lord.
Third learned counsel for additional PP decision application. So and so. The second bail application in respect of the present petitioner, the full stop, the previous bail application was rejected by order dated annexure earlier.
My lord, it's 3.
No, page.
My lord, we will kindly come to page number. I just wanted 40, my lord. It was 42, my lord. 42, my lord. 42. Page 42.
Earlier rejected on
28/1/26.
Twenty-eight 1/2026 in bail application 3860 of 2025. Don't say rejected, was
disposed, my lord.
Closed and disposed of as the charge sheet had been submitted. Subsequently, the learned trial court has rejected the bail application of the petitioner. Full stop. The as per the allegations reflected in the FIR, upon house search of the house of the petitioner, a commercial quantity of narcotic drugs, psychotropic substances were recovered. Learned counsel for the petitioner. It's that the petitioner has been in custody for the last how many days?
And it's yeah, my lord, he's in jail since 9/8/2025, my lord. Till almost 300 some days, my lord.
Give the date since so and so. 9/8/25.
2025.
And after the charge sheet has been submitted, only 3 witnesses have been examined, and 4 witnesses are still left to be examined. And the next date fixed is what?
And it's 10/8/2026.
2026. Therefore, the learned counsel for the petitioner submits that petitioner is entitled to be released on bail on account of delay in the trial. It appears that the charge sheet was submitted and cognizance thereof was taken on 8/12/2025. And
First frame on my note 16 to
16
2026.
16 to 2026.
charge was framed. Charges were framed on 16/2/2026. So therefore, it appears that only 6 months have elapsed since the commencement of the trial, in course of which 3 out of 4 witnesses have already been examined. From the above, I do not find that any such delay in the trial has been occasioned so as to infringe the constitutional rights of the petitioner. Furthermore, having regard to the material available on record, the provisions of Section 37 of the NDPS Act are squarely attracted. In view of the above, the prayer for bail stand rejected at this stage.
At this stage. However, my lord, I may have a liberty, my lord, if it doesn't proceed.
Even we can say no further bail application will be entertained.
That's a different issue. All right, my lord. May it please your lordship, the petitioner is 20 years old, lordship. This is an anticipatory bail application. So the FIR is at page number 13, lordship. That is the original copy, and the typed copy at page number 9, lordship. The allegation pertains to abatement of suicide, lordship.
Page 9.
The typed translated copy, lordship.
Yes.
The commencement of the relationship, the boy was about 19 years old and this girl was about 16 years old, lordship. And two essential ingredients for to make out the offense of abatement of suicide, lordship, is not present in the present case, lordship. I have committed a judgment also in that regard before your lordship. One being that there was no direct instigation to commit suicide, lordship. There are allegations of harassment, lordship. And secondly, it is admitted that the girl was at her own home, lordship. It was not that she did not have any other option other than committing suicide, lordship. There are two essential ingredients, lordship.
IO's note refers to the messages. Any messages are enclosed?
Those messages are not enclosed, my lord. My lord, there's a mobile, my lord, they, my lord, here, my lord, the CDR is, my lord, there, my lord. And my lord, there, my lord, in the, my lord, bail objection, they stated that, my lord,
If the messages are not before us, then how can we say simply because the IO says instigative? The problem is that nobody is saying anything about actual content. There are messages indicative of so and so. There is audio recording indicative of that. Nobody says what is the content of that.
At this stage, whether my lord updated CD may be called for, my lord, with a direction whether my lord some transcripts or something is.
This is dated when last date is 12/7. Her mobile has also been seized. So
That is my lord seized, my lord.
IO keeps repeating about electronic evidence. He will
Electronic
tamper with
evidence.
evidence and all that. If it has been seized, what will he tamper with?
And for my lord,
As far
assistant
as his
also
own mobile is concerned, whatever tampering is to be done has already been done. If any. He has exchanged messages that will be available in the mobile. How is he going to interfere now? Third learned counsel for the petitioner. Additional PP. Application under so and so. The allegation as per the FIR lodged by the brother of the victim is that the petitioner was in a love relationship with the minor sister of the informant. And the petitioner used to inflict physical and mental torture because upon the victim, because of which she took her life on 20/04/26 by hanging herself. And that on the day of occurrence, she had called the accused person and told him that she would commit suicide within 10 minutes. And also as per mobile recording of his sister, cause of her death was the physical and mental torture inflicted upon her by the accused person. And counsel for the petitioner submits that there is no abatement by way of instigation or otherwise on the part of the petitioner, the commission of suicide by the victim, and the petitioner himself is a young person. Is it about
Presently 20 years, Lord.
20 years? Was in a love relationship with the victim. Have you stated any reason for our commission of suicide?
Which I have said there may have been some relationship dispute, but it was not that I ever instigated her to.
Where the CDS call for has been received. Appears that the mobile phone of the victim has been seized and sent for forensic examination. Although the IO has stated that as per CDR, several messages were exchanged between the petitioner and the victim, the date of occurrence. And according to the informant, there is also a video recording of their conversation. Nothing of the sort is available. CD. Therefore, at this stage, it cannot be said that there is still to indicate that the accused had abetted the commission of the suicide by any investigation or otherwise. In regard to the of the therefore pre-arrest bail. To sureties of like it was interim.
No, Lordship.
IO within a period of 10 days from today. Cooperate with the investigation. Further provided that the petitioner shall not try to influence or imitate the family members of the victim in manner. Petition stands disposed.
Much obliged.
Item 50, my lord, CD not received, my lord. There was interim was there. my lord.
CD not received. List again, so and so interim. Continue.
$25,800.
Interim may be continued, Lord. If you.
May I please, Lordship? Lordship, LSAT is received. And the Lordship, in this case,
Is here.
yes. Lordship, in this case, a charge sheet was filed under section 306 of Indian Penal Code. And the Lordship, the fact of the case is that Lordship, in this case, Lordship, the deceased person committed suicide on 22/8/2022. And later on, Lordship, on 23/8/2022, a suicide note was found. On that basis, the affair was lost, Lordship. And the Lordship, during the investigation, the police personnel did not call for me. And the Lordship, thereafter, the police personnel filed the charge sheet, and it was shown the absconded to me. And the Lordship, during the investigation, I was not called for by the police. And the Lordship, now the charge sheet has been filed under section 306. And the Lordship, what is the content of the suicide note, Lordship? I don't know.
There's my CD part is not there. Otherwise, it is there only.
Suicide notice here.
No, my CD part, my lord, is not
here.
the others.
There are some irregularities, Lordship. I want to draw some irregularities, Lordship. So
Postmodern and FSL is there. That is.
Kindly peruse the Annexa 2 Lordship. There are some irregularities in the seizing the documents Lordship. Because Lordship, the learned magistrate mentioned some irregularities Lordship. At the time of Lordship, Caesar list Lordship, the date, time, and the place was not mentioned. And the IO has created to give the Zimma to the Caesar list to the informant Lordship. So Lordship, there are some irregularities. And the Lordship in the search.
There are no statements or even no statements or anything, nothing is there.
Nothing is
What
there.
are we supposed to do with this TCR?
Only the PM is there and FSO. The CD part may be called from another.
PM suicide is not denied by anybody. So PM is hardly of any significance.
Lordship, I may be allowed to go on bail, Lordship, because Lordship, the case is pending before the committing court, and that court has not the jurisdiction to grant me the bail. So, Lordship, I may be protected.
You'll appear therefore apply for regular bail.
No, Lordship, this is AB Lordship.
Huh?
AB Lordship, because the Lordship, in the trial court, the case is pending, but Lordship, I cannot appear because Lordship, committing court
in the
has not power.
investigation, madam. He has not participated in the investigation. That is why you are known as absconder. Madam.
But Lordship, during the investigation, police did not call me to appear before the police. The Lordship, when I received the summon, then only I came to know that the charge sheet has been filed. And the Lordship, I have no any relation to the deceased person, Lordship. But Lordship, how the case charge sheet is filed against me, Lordship. And the Lordship, in the charge sheet, Lordship, nothing was mentioned that how I instigate the deceased person. Only it was mentioned that one the suicide note was found. But what is the content of the suicide note was not mentioned. Neither it was mentioned in the FIR nor in the charge sheet, Lordship. Lordship, I may be protected, Lordship.
FIR it is mentioned.
Yes, my Lordship, in the FIR, what is the content of the suicide note is not mentioned, Lordship. Kindly peruse the FIR, Lordship. Annexa 10, Lordship.
And it just
Thus, it was
implicated the accused. That is there, but in the
the Lordship, there is no
Let us have the CD then. Without seeing anything, I can only grant you blanket protection. You want to appear and apply for regular bail, there you apply?
No, Lordship, because Lordship, if I appeared to the committing court, then the Lordship committing court has not the power to grant me the bail, Lordship, because this is under tribal by the session court. And the Lordship, my prayer is that the Lordship on the merit this application may be disposed of. And the Lordship, the suicide note is not found on record itself, Lordship.
What record?
No. Because Lordship, I applied a certified copy, but Lordship, I have not received any copy. And the Lordship, I don't know the contents.
That is why we will have to see the CD.
Yes, then Lordship, maybe call for the CD, Lordship. At least, Lordship, what is the contents of the suicide note?
Although the TCR has been received, the CD is not available. The purported suicide note pertaining to the present case is also not available in the and copy of the TCR, and neither is any statement of any witness. Hence call for the CD. Please take a note.
Always, Lordship.
unappears manner, but they are on interim. A CD not received.
Unappears CD not received. List again on so and so interim to it.
Attached. Get down all the cases.
I am on interim, my lord. The petitioner is a female person. We have also appeared, my lord. Item 53, my lord.
Dated 27.
Yes, any role is attributed.
The record is not before us, man.
It did not come.
No, man, it's seated, man.
Not cited. 354 and 60.
And 60, man.
Learned Council, learned additional PP submit. Charge sheet has already been. CS number.
CS number 231/26 dated 27/26.
Huh?
Item 60.
60.
Regular bail application. Set from attack against him. 3 days, Your Lordship.
Approach there, man. Otherwise, again, notice has to go, my lord, and
Lordship, may kindly tell us.
Mutir Rahman.
Mutira. Then accused is Anwar Hussain.
Right, 53, 54, you write.
Lordship, I am for
submit-
53,
submitted and
Lordship.
call for the TCR. Please take in on so and so interim order first earlier to
53.
continue till the next of listing.
54, 54.
53, 54, both interim order is there.
Lordship, Lordship.
So what is the allegation against you in 60?
When accused, Anwar Hussain stated something against me. He stated the ground of arrest, may kindly tell us. Case 15.
Eh?
Case 15, Your Lordship. Ground of arrest. When accused, I provided the pregnancy termination tablet. Allegation against. False, my lord.
Learned Council. This is a 60-day offense. You are 58 days.
50 days.
yes, my lord, 90 days offense. 90 days offense.
No, no, he's
Also,
supplying.
Days, Your Lordship.
Learned, all right, had learned counsel for the petition and application under so and so. The allegation as per the FIR is that the main accused of the case, namely Anwar Hussain, had a physical relationship with the victim aged about 17 years, as a result of which she became pregnant. The allegation against the present petitioner is that he had procured and supplied medicine for termination of pregnancy to the principal accused, which was consumed by the victim and ultimately it led to her. She died, didn't it? Victim died.
Right, Lordship.
Led to her death. There are Similarly situated co-accused of the case. This is similar, say co-accused per Dalur Rahman and Taz Begum have been granted interim bail by order dated 16/7 passed in AB 1543 2026. All Afzalur Rahman rile hobo, ha, baki to. And another co-accused, Mumtaz Begum, alias Mumtaz Begum, has also been granted interim bail by order dated 20/07/2026 in AB 1581 of 2026. The charge sheet in the case has already been submitted. Having regard to the nature of the allegation against the present petitioner, which are not directly under the POCSO Act, having regard to the fact that the petitioner has already spent 50 days in custody. That the petitioner be released on interim bail of rupees 50,000 with two sureties of like amount to the satisfaction of the Lord. So, which court is this? Special court POCSO? Which place?
Gauhati.
Is the matter again on? Other case notice is already issued, I think. So if it is no need to issue notice separately in this case. Same date.
In case of item 53 and 54, 27.
Item 60 is this.
Not disposed of. You are only granted interim bail.
Much resolution.
List along with 53, 54.
The office note says, my lord, the TCR has not been received, my lord.
Item 60 is disposed. Not disposed of. You are only granted interim bail. List along with 53, 54. List along with 54.
Office note says, my lord, the TCR has not been received, my lord.
Item 60 is disposed. Not disposed of. You are only granted interim bail. List along with 53, 54. List along with 54.
my lord, TCR has not been received, my lord.
Oh, yes. Yes.
As per office note, my lord, TCR has not been received. Earlier it was called for. Then copy of TCR was called for.
Yes, sir. Yes. Can copy received?
Can copy not received, my lord. They are on interim, my lord.
Can copy of TCR not
Here, my
received?
lord, 2nd of September, my lord.
Again, I'm so so interim passed earlier to continue.
Same, my lord, 66.
It's also got IAPR.
All right.
Published.
Criminal appeal, my lord. 430, my lord. Subsection 2 application, my lord. Here, what has happened, my lord? A boy, my lord, there is a proposal of marriage, my lord. And thereafter, my lord, the marriage could not be solemnized because of some differences, my lord. Now, the factual matrix is, well, I'll show the evidence also, my lord. On the sole testimony of the victim, conviction was, my lord, announced by the London lower court, my lord, the Court of Sessions, my lord. That I'll come, my lord. What I'm on now, my lord, the girl has married after conviction, my lord, with all respect, my lord. The victim has married a different boy, and my lord, the accused, his wife, both may be friends also, my lord. I do not know the factual metric actually. And one lawyer has been engaged by the, with all respect, my lord. First in for the victim's side, my lord. With all respect, my lord. That is a different aspect, my lord. Possibly they may not have any objection. That's a different matter. But so far as the merit is concerned, my lord, the state filed an objection, my lord. I'll take 2 minutes into it, my lord. And my lord, the exact documents, my lord, the evidence and everything, possibly there never can be a conviction also. Sorry, my lord. It would be.
My lord, they filed yesterday, my lord, it is not in record, my lord.
No, I have given a copy, my lord. It cannot be on record. Fixed sentence of 10 years, my lord. Fixed sentence of 10 years, my lord. Objection has been filed by the state. And thereafter, my lord, Lordship would kindly have a look, my lord, it all the documents we have given by a bunch, my lord. FIR, my lord, the bunch, my lord, it is at page 2, my lord, in vernacular, my lord. Lordship may have found, my lord. Leaving aside 5-6 lines, my lord. I'll be very cryptic, my lord. শেষত যোৱা ইংৰাজী 5-10-21 তাৰিখে 1 নম্বৰ পদকীয়া আমাৰ ঘৰলৈ আহি অনতি পলমে মোক সামাজিকভাৱে বিবাহ কৰিম বুলি নি পত্নীৰ মৰ্যাদা দিম বুলি প্ৰলোভন দেখুৱাই মোৰ লগত শাৰীৰিক সম্পৰ্ক স্থাপন কৰাৰ প্ৰস্তাৱ দিয়ে 1 নম্বৰ পদকীয়া তেনে প্ৰস্তাৱত প্ৰথমে মই সন্মতি প্ৰকাশ নকৰাত পদকীয়াই বিভিন্ন কৌশলেৰে মোক সন্মতি প্ৰকাশ কৰিবলৈ চেষ্টা চলায় অৱশেষত পদকীয়াই ইচ্ছাৰ বিৰুদ্ধে মোৰ লগত শাৰীৰিক সম্পৰ্ক স্থাপন কৰে goes on and on, thereafter leaving aside 2 lines. 1 নম্বৰ পদকীয়া আকৌ যোৱা ইংৰাজী ইমান তাৰিখে মোৰ লগত হাজু থানাৰ অন্তৰ্গত সোৱেঞ্চ গাঁৱৰ বাইদেউ নমিতা মালাকাৰৰ ঘৰত আহি আলহী হিচাপে যোৱাত সেই নিশা প্ৰায় 9 মান বজাত পদকীয়াই পুনক মোক বিবাহ কৰি নিয়াৰ প্ৰলোভন দেখুৱাই মোৰ ইচ্ছাৰ বিৰুদ্ধে মোৰ লগত শাৰীৰিক সম্পৰ্ক স্থাপন কৰে These are the allegations, my lord. Thereafter in evidence, my lord, Lordship may kindly have a look at page 5, my lord, the 164 statement. Definitely not of sterling quality, my lord. Page 8, my lord, with all respect, my lord. It begins at, my lord, page 7. Page 8, the 164 statement. I'm reading para 3. Oh, I'm sorry, the evidence, my lord. I'm reading para 3, my lord.
Where? From your bunch?
My bunch. I'm sorry, my lord. Page 8 of my bunch, my lord.
Page?
Page 8, my lord.
Yes.
Lordship may have found, my lord. Thereafter, his relative and family members often came to our house but we did not go to their house. On 5/10/21, evidence, my lord, he came to our house and was talking with me, and at the time, my father went to his job. My mother was busy in cooking in the kitchen. Mother was there, of course, in the house, my lord. The accused insisted me for sexual intercourse with him, and when I refused him, he assured me that since he would marry me, so I should agree with him for physical relation. We were alone in the room. However, in spite of my resistance, the accused committed sexual intercourse with me. Thereafter, he returned to his house. Mother has not been examined, my lord. Next, there are two incidents, my lord. On 17/10/21, I went to the house of my married elder sister, namely Nomita Malakar at Haju. The accused, having got to know about my visit to the house of my elder sister, came to my sister's house on 18/10/21. At a time, the husband of my elder sister was out of home in his police duty. The accused was having conversation in a lonely room, and he insisted me to have sex with him, to which I prevented him. We had some verbal quarrel regarding the physical relation. I tried to make him understand that physical relation before marriage is not good, and then the accused told me that he was going to inform the husband of my elder sister that he was not going to marry me due to my problem. I got frightened because people of our locality knew that the accused would marry me. Accordingly, the accused influenced me to commit sexual intercourse with me against my will. She was a lady of 26 years of age, my lord. 26 years of age, my lord. This is the evidence part of it, my lord. And thereafter, my lord, with all respect, my lord, Lordship knows, my lord, more than me, my lord, with all respect, my lord. Fixed sentence, my lord, 10 years, my lord. And here, what has happened, my lord, with all respect, my lord, the authorities, Lordship knows, my lord. Anyway, I'm just placing it, my lord. One is, my lord, 90, the law, it came in 1999, floodgates were open, my lord. Bhagavan Ram, my lord. There also a case of 10 years, my lord. To buy the Dibonigi. Lot of flaws in the prosecution, my lord. Mother was not examined, other households, and those are immaterial, my lord. The statement of the lady itself shows, my lord. This, my lord, 99, my lord. This Bhagavan Ram, my lord, Lordship knows, my lord. This is 10 years, my lord. Imprisonment for, my lord. I'm reading para 3, my lord. Lordship may have found, my lord.
Yes.
May I read para 3, my lord? When a convicted person is sentenced to a fixed period of sentence, and when he files an appeal under any statutory right, suspension of sentence can be considered by the appellant court liberally, unless there are exceptional circumstances. My lord, there are no exceptional circumstances. In fact, a positive circumstance that the lady, my lord, has engaged the lawyer, the victim, my lord. Possibly, my lord, that he would be saying, my lord, no, I am not to open my mouth, my lord. This much, my lord. And there were several other authorities subsequent to, my lord, with all respect, my lord. The 1999 authority of Bhagavan Ram, my lord, that was also a 10-year fixed period sentence, my lord, with all respect, my lord. Thereafter, there is another 2001 authority that also I have placed before your lordships. Therein also, my lord, Bhagavan Ram has been quoted in para 3. The court has held that Bhagavan Ram Sinde Gosai versus so and so, that when a person is convicted and sentenced to a short-term imprisonment, that normal rule is that when his personal appeal is pending, the sentence should be suspended and rejection is only by way of exception and be put forward for such rejection. So when it is fixed period, my lord, normally, possibly bail is the rule and non-grant of bail is the exception, my lord. And here, my lord, the further positive side is, my lord, the lady may not have objection, my lord, the victim, I am meaning thereby, my lord. And both the girls, my lord, to be honest, my lord, of course, should I say or I shouldn't say, my lord, the accused wife, who is in one convict's wife, my lord, sorry, my lord, Dita Bundu, no? Convict's wife, my lord, and the victim, my lord,
How long in custody now?
From the date of judgment, my lord.
Around 3 months.
3 months, my lord.
3 months. 3 months only.
No.
From the date of judgment.
Possibly, my lord, of course, I shouldn't say, had it been trial, of course, my lord, here it has ended in conviction, my lord. Had it been trial stage, my lord, if this is sort of a, my lord, with all respect, my lord, climax should have arrived at, my lord, then possibly there would not have been any conviction, my lord. Of course, now there is conviction, but my lord, fixed period, and my lord, the rest, my lord.
But yes, conviction was granted, given on the basis of the vital statement of the victim. And there are catena of judgment of the Honorable Supreme Court that yes, conviction can be granted, can be given on the basis of the statement of the victim. And C categorically stated 164 also in just evidence in PW1 also C if is not allowed to physical relation, then marriage will be broken. That was the one threatening in the house of his elder sister also. That threatening was that I will told your brother-in-law that I call you the brother-in-law that I'll not marry you if not. This was the threatening. Under compelling circumstances, that is what girl is major. That is another thing. But marriage was fixed, and before 10 days of marriage, one telephone came that I will not marry you. Before that physical relation. And there are judgment also, of course, at that point of is now not available with me. If there is possibility, for allowing the appeal, then in that case, bail can be granted, and or if around half of the punishment. Well, now only 3 months, 10 years conviction, only 3 months.
That authority, my lord, I am not aware regarding her, but here, my lord, any fixed period, that 99 authority itself was 10 years, my lord. Here also 10 years, only mitigating circumstance, my lord, the lady maybe, if possible, my lord.
May I please?
Mother, kindly see, my lord, the mother was not examined, mother was at home, my lord.
So who will find the judgment for you?
Several cases,
Lakhinder Singh is
That is Lakhinder Singh, my lord. The tenor is different, my lord. There is no bar, Lakhinder Singh. But Lakhinder Singh would not be the authority here. Here the authority would be that 1999 authority, my lord. Fixed period. And they are also categorically same strata, my lord. 10 years. Here also 10 years, my lord. And here the mitigating circumstance, my lord. Let the girl side, if possible, my lord, let him be heard, my lord. Earlier, my lord, amicus was appointed because nobody appeared. Yes. Now, my lord, the lady has appointed a lawyer, my lord.
Yes, yes. I have been engaged by the informant. At the time of the incident, she was 26 years age, and my lord, marriage broken and all that was FIR was lodged, my lord. Now, my lord, she is married and having 5 years month child, my lord. So she has regarding the bail itself, she has no objection. That is my instruction, my lord.
Instruction from your client.
Yes, client. Informant.
And material instruction from this side.
No, my lord.
We'll see.
My lord.
If you have any judgment to submit, submit.
I'll put it in.
You have half an hour.
My lord. My lord.
In that.
That in বাকিটো পিছত দিম, এইটো খালি লিখি থব। Appearance of privately engaged counsel, amicus is released.
Obligable.
Much obliged.
May I please, your lordship? In this case, so far as Milord service in respect of respondent number 19, Milord, we have taken the steps, Milord, but the service is awaited, Milord. On 15/7/2026, steps were taken here.
Service on respondent number
19 my lord.
19 is not yet complete. So it is submitted that steps have been taken.
Right.
Await service is taken on.
But can I have a date, my lord? Obliged.
For hearing. 57.
And here lordship has called for a report from the jail lordship, whether the convict is still in jail or he has been out, because already 7 years he has completed. That was through the registry, I think, lordship. Reflected in the last order, lordship.
Report not yet received. As per office note dated 27/7/26. Report from district jail Borpeta, from Superintendent District Jail Borpeta has not yet been received. And list the matter again on 2 weeks episode date. Registry to issue reminder.
My lord, may I seek your lordship's liberty, my lord, that my friend has referred to the judgment, my lord. Here itself, my lord, it has been stated, my lord. My lord, in Narcotics Control Bureau, Bhatet, Lakhinder Singh, my lord. This is the authority, my lord. They are in, my lord. I'm reading it and placing it before your lordships, my lord.
He has not referred. You have got it out of his.
No, that authority, Lakhinder, he is
He may have something else in mind. We don't know.
Well, Lakhinder, but that half, my lord. Can I just say academic, my lord? With all respect and tolerance, my lord. My lord, that relevant part I'm reading, my lord. Even if the accused has not undergone half of the sentence, my lord, that is in para 5, my lord. Lakhinder Singh, this is the only authority, my lord. That half has been negated, my lord. Any consideration and my lord, other, of course, mitigating death sentence, my lord. My word may be wrong, my lord. Para 5 last part, my lord. And para 6, my lord. Lakhinder Singh, paragraph 5, last part, last 3 line. And para 6, my lord. In the case of fixed term sentences, my lord. My lord.
Yes. This was item number
56.
56 DD Basun Pathak.
I'll submit the code, Master.